Moving on. Justice Jackson.
So I want a declaratory judgment in order to deal with prospective, my prospective exercise of my religious beliefs. But if I'm a prisoner, you say no. Is that right? Like, so your big fulcrum is in or out of jail.
When it comes to prospective relief, when it comes to any sort of retrospective relief related to the conviction, including damages, we don't think it matters whether you're in or out of custody.
But when it comes to prospective relief, a prisoner does not have the ability to request from the court prospective relief concerning the violation of his constitutional rights if he's in jail.
Prospective relief, and I know I'm caveating, but we think it's an important caveat. Most prospective relief from a prisoner will be fine, but if it necessarily implies the invalidity of his conviction, that's where we understand this court's decisions in Edwards, Wilkinson, Skinner to carve out, and that's the line we're trying to hold in this case.
So if a person is out, and going back to Justice Gorsuch, an example that you were exploring with Justice Gorsuch, he's out and he wants to deal with the collateral consequences of his conviction. And so he brings this 1983 suit. Is that okay or not? I think you said it might be barred, but I don't understand because no habeas consequence, it's not doing an habeas in run at that point. So why would that be barred?
So we start from the baseline that a federal court cannot sit in review of a state court judgment. That goes all the way back to Rooker-Feldman.
But that's not in the Heck line of...
And that's not even in the...
Okay.
You don't even need to depend on the Heck line of cases for that. So if he's bringing that type of suit, please invalidate my judgment through Section 1983. We think that's out.
Barred for this other reason.
Barred for this other reason.
Okay.
But if he's asking for a declaratory judgment or injunctive relief because he wants to engage in the activity in the future, we think he can properly proceed, and the court doesn't have to sort of scrutinize what does he really want to do here. The court can focus on the nature of the harm alleged, and if he really does have that credible fear of prosecution, he can bring the pre-enforcement suit.
Thank you.
Thank you, counsel.